treatment of indigenous legal traditions within court systems. When most people think about U.S. law, they picture the Constitution, Supreme Court rulings, and a very long list of legal terms nobody actually understands. But what often gets overlooked is that long before the U.S. existed, indigenous nations already had complete systems of law, systems built on restoration, responsibility, and community balance. And despite colonization, boarding schools, federal termination policies, and centuries of outright suppression, those legal systems did not disappear. In fact, the most fascinating part of this topic is that indigenous legal traditions have survived not because Western courts protected them, but because indigenous communities actively resisted their erasure. That survival through resistance lens is the angle I'm focusing on today. Let's start with the work of Matthew Fletcher, an important Native legal scholar. In his 2007 article, Rethinking Customary Law and Tribal Court Jurisprudence, Fletcher explains that tribal courts today still rely on customary law, meaning the values, stories, and principles that guided Native governance for generations are still there. These aren't symbolic traditions. They're applied in courtrooms where judges make real decisions about families, disputes, and community safety. Fletcher argues that this use of customary law shows a form of legal continuity. Despite federal policies that try to replace indigenous governance and Western models, tribal courts have found ways to adapt and incorporate their own laws. This is surviving through practice, through memory, and through legal decision-making that reflects indigenous worldviews rather than just copying Western ones. Now, another scholar, Ezra Rosser, adds a different but equally important perspective. In his 2008 article, Customary Law, The Way Things Work, Codified, Rosser talks about what happens when tribes choose to codify their traditional laws, meaning they formally write them down, organize them, and implement them as part of their legal traditions and codes. And this isn't just administrative paperwork. Rosser says that codifying indigenous law is a form of political resistance. It's tribes asserting authority over legal identity, saying, our law doesn't need to look like federal law to be legitimate. Codification strengthens sovereignty because it puts indigenous legal traditions into formats that both tribal members and outside courts can reference. It becomes harder for non-tribal courts to ignore indigenous law when it's written, structured, and used as part of official governance. So where Fletcher emphasizes survival through practice, Rosser emphasizes survival through formal assertion of authority. Both show resistance, one in everyday application, the other in institutional structure. But what's really important here is what this means inside modern court systems. Mainstream U.S. courts, federal and state, still tend to treat indigenous legal traditions as interesting cultural information rather than equal systems of law. And that creates real tension. When tribal courts incorporate traditional law, they're not trying to recreate Western justice. They're offering a different vision of justice, one that focuses on healing relationships, sustaining communities, and restoring balance. This is why the survival of these traditions matter. They challenge the dominance of Western legal thinking and remind us that justice isn't just a single model. It's multiple systems coexisting, or at least trying to. Together, Fletcher and Rosser show us that indigenous legal traditions haven't survived accidentally. They've survived through a deliberate resistance, adaptation, and community commitment. So at the end of the day, indigenous legal traditions aren't symbolic. They're active, functioning systems of law that continue to grow and evolve. And when courts take them seriously, they're not doing indigenous nations a favor. They're finally catching up to something indigenous communities have known for generations. Thank you.